Get started. Thank you so much for joining us today. I'd like to welcome you all to our Human Rights webinar on a right to a healthy environment. I would also like to thank our speaker and all of you for taking time out of your busy schedules to join us today. This webinar is being recorded, and the recording should be available on our website at www.wclcenterforhr.org later today or possibly tomorrow, depending on how long it takes to upload. If you have any technical problems or issues, send us a message using the dashboard question box or chat box on your screen, and we'll do our best to help you with those problems. My name is Lauren Bartlett. I'm the project director of the local Human Rights Lawyering Project here at the Center for Human Rights and Humanitarian Law at American University Washington College of Law. The local Human Rights Lawyering Project works to normalize human rights at the local level here in the U.S. by providing training, coaching, and resources to legal aid attorneys and public defenders to integrate human rights into your daily work. Legal aid attorneys, public defenders, as well as human rights and other public interest advocates have come to look to the local Human Rights Lawyering Project as a key source for guidance and trainings in integrating human rights into U.S. advocacy. The Human Rights in the U.S. Handbook for Legal Aid Attorneys is a practical and easily usable guide for integrating human rights into your work. We just released a new version yesterday, which has a Right to a Healthy Environment chapter, and it can be downloaded from our website. We're holding this webinar today to talk about how to integrate human rights into environmental cases. Erica Lennon will be providing an introduction to the right to a healthy environment, and I'm going to help guide you through building a human rights argument to use in a U.S. court. There's going to be plenty of time at the end for questions, so please hold your questions until then. We'll go ahead and unmute you at that time. But again, if you have any technical difficulties, send us a question or use the chat box on the webinar dashboard. I'm now going to go ahead and introduce Erica. I also want to let you know that you can download a copy of this PowerPoint presentation from our website here at this web address if you want a copy to take notes on or for future reference. So I'm going to go ahead and introduce Erica just briefly. Her bio and my bio are also available on our website if you want our full background. Erica is the program coordinator for the program on International and Comparative Environmental Law here at American University Washington College of Law. Erica is a lawyer focusing on international finance, environmental law, and climate change. Erica helped lead the WCL contingent to the international climate negotiations in 2009, 2010, and 2011. And again, her full bio is on our website. She's going to go ahead and start you off with an introduction to the right to a healthy environment. Okay, go ahead, Erica. You're the presenter.
Hi, everyone. I'm Erica, and I'm going to give a brief overview of sort of the background to the right on a healthy environment and up to where we are now. So really, the right to a healthy environment started in the early development in the early 1970s.
You were just muted.
Sorry, everyone. I appeared to have been muted. I thought I wasn't. Anyway, hi, I'm Erica. I'm going to give a brief overview of the background to the right to a healthy environment, starting in the early 1970s when the right really started to develop and when environmental laws started to develop around the world, and up until now. So basically, in the early 1970s, we saw the development of both of the recognition of environmental harm and the development of laws, regulations, principles to help combat environmental degradation and ensure a healthy environment, clean air, clean water, etc. for people. Reducing the amount of transboundary environmental harm, reducing the amount of hazardous waste. In 1972, there was the first UN Conference for the Human Environment, commonly referred to as the Stockholm Conference, and in the Stockholm Declaration, it was the first time there was really a recognition of this right to a healthy environment. In the preamble, paragraph 1, it says both aspects of man's environment, the natural and the man-made, are essential to his well-being and to the enjoyment of basic human rights, even the right to life itself, the environment for present and future generations. So basically, this was the first time that we recognized both a right to a healthy environment, not only that it's people's jobs to help protect the environment, but also that in order for people to live a decent life, there needed to be a healthy environment around them. In addition to the international agreement of the Stockholm Declaration, national level developments started happening around this same time. So in the early 1970s, the U.S., which does not necessarily have a right to a healthy environment established, did start establishing environmental laws such as NEPA, the Clean Water Act, the Clean Air Act, regulations of toxics, etc. Other countries also began developing laws. And in 1976, Portugal became the first country to include a right to a healthy environment in their constitution. Between the early 1970s and now, there have obviously been significant developments, both internationally and domestically. The 1992 Rio Declaration, which was the follow-up to, which was 20 years after the Stockholm Convention, was a follow-up, reiterated the right to a healthy environment in its Principle 1, where it said human beings are at the center of concerns for sustainable development. They are entitled to a healthy and productive life in harmony with nature. The Rio Declaration is often cited as one of the sort of fundamental, as having a lot of the fundamental principles of international environmental law and laying out principles of sustainable development. Additionally, domestic laws continued to develop both in the U.S. and elsewhere about reducing air and water pollution, regulating toxics, conserving wildlife, conserving natural resources, etc. And in 1994, President Clinton issued an executive order that directed the EPA and other agencies to make environmental justice part of their mission to the greatest extent practicable and permitted by law. Obviously, this is very good. It has a lot of caveats in it, as do a lot of international environmental laws that sort of make sure that there's a balance between protecting the environment and allowing for development and things like that. And so this obviously also has the caveat of the greatest extent practicable. But it's excellent, but it was one of the first times the U.S. recognized the sort of environmental justice issue and the right to a healthy environment in the federal law. Additionally, over this, between the 1970s and now, there have been numerous international treaties developed addressing ozone layer depletion, the Montreal Protocol, addressing toxics, addressing biodiversity, desertification, the transboundary movement of hazardous waste, persistent organic pollutants, trade in endangered species, marine pollution, climate change, etc. Some of these treaties are obviously stronger than others. Not all of them have been ratified by the U.S. This is also, in addition to the environmental treaties, there are also a number of human rights agreements, rights to access to information, etc. Most recently, or currently, out of the UN member nations, 177 of them recognize the right to a healthy environment in some way, either through the Constitution, legislation, a court decision, or ratification of an international agreement that includes the right to a healthy environment. Additionally, 92 countries have the right to a healthy environment, have added the right to a healthy environment to their constitution since the mid-1970s. Though the U.S. does not have a right to a healthy environment in its constitution, 6 U.S. states recognize the right to a healthy environment, including Hawaii, Illinois, Massachusetts, Montana, Pennsylvania, Rhode Island, New Mexico, and Washington also do. And the city of Santa Monica recently, in 2013, passed a sustainability rights ordinance, even though the California Constitution and legislature doesn't have the right to a healthy environment in it. A lot of those laws, much like all the a lot of the U.S. environmental laws, or those changes were passed in the early 70s. There are obviously, despite the momentum and the development of these international agreements, of the right to a healthy environment, of domestic laws around the world, there are still a lot of problems and a long way to go on protecting people and the environment. Currently, 780 million people worldwide lack clean water or lack access to clean water. Here in the U.S., 13% of people living on of American Indian and Alaska Native homes on reservations do not have safe drinking water and sanitation or sewage disposal. Obviously, climate change is in the news a lot and is a huge problem, with the U.S. and China continuing to be the largest emitters of greenhouse gases. But if it goes unchecked, we're going to be in serious trouble. And it obviously causes a lot of problems for human health, both related to drought and flooding and those aspects, but also the release of these pollutants lead to asthma and other lung diseases and problems, especially in children. For example, the majority of people in the U.S., 56% of the people who live near a large hazardous waste facilities are people of color. This is true both in the U.S. and around the world. Oftentimes, the place where the government or companies decide to put toxic waste plants, coal-fired power plants, and other polluting, really large-scale infrastructure is near either the poor or disadvantaged communities. Finally, in 2012, the UN appointed its first independent expert on human rights and environment and really sort of brought to the forefront the link between human rights and environment, which many people knew before that, but now it's the UN officially recognized it. The first independent expert is John Knox, who's a professor at Wake Forest. And he noted that the emerging law of the environmental human rights is clearer than ever before, and that a healthy environment is fundamentally important to the enjoyment of human rights, and the exercise of human rights is necessary for a healthy environment. There's really, rights don't exist in a bubble, and you really cannot have, many human rights are impacted if there's a lot of environmental degradation, and so you need a healthy environment to really exercise your human rights. For example, John Knox noted a number of human rights which are more susceptible than others to certain types of environmental harm, including the right to life, the right to health, the right to food, the right to water and sanitation, the right to adequate housing, the right to non-discrimination, and the right to self-determination. All of these are obviously impacted if there's poor environmental conditions and you're breathing in bad air, if you don't have access to clean water, if you can't grow your crops because climate change has made the growing season different or is causing massive flooding. Additionally, there are a number of procedural rights that are vital to environmental protection. And that one of the ways to ensure that the environment can be protected is to assert these procedural rights, including the right to freedom of expression and association, the rights to receive information and participate in decision-making. This is noted in relation to free, prior, and informed consent, to consultation when you're developing, when there are large infrastructure projects. This happens especially in other countries. There's a lot that you can do with things like the Freedom of Information Act here in the U.S. or access to information. Recently, some Indian access to information activists have started getting coal plants in India shut down because they weren't properly consulted, and the Indian government recognizes the right to information, and that's what they use to bring about these sort of environmental rights. You also need rights to legal remedies. This is one of the biggest problems with environmental laws, is that not only do you need the environmental laws and the right to a healthy environment, there needs to be a way to enforce that. And so in order to enforce that, you need access to effective remedies. This is often a problem. U.S. courts haven't necessarily really accepted the right to a healthy environment generally as a principle. There is a U.S. law that allows, called the Alien Tort Claims Act or the Alien Tort Statute, that has been used by non-U.S. citizens to bring suits in U.S. courts for torts committed in violation of the law of nations or a treaty of the U.S. So this is one way that you can sort of use international law, but it has been very, very limited thus far. The Supreme Court has recently limited again. It generally is limited to serious violations related to genocide, piracy, war crimes, things of that nature that are sort of these specific international rights that are more well established, they think, than the right to a healthy environment. And basically, overall, it's nice that they're finally, rights don't exist in a bubble, and lots of human rights are impacted by the right to, by whether or not there's a healthy environment, and the right to a healthy environment helps protect human rights as well. And so all of these are interconnected and interdependent, and it's exciting that people are finally realizing that and talking about it. Thank you.
Okay, everybody. So thank you, Erica, so much for your presentation. That was great. Sort of there was a background introduction to the right to healthy environment. I'm going to go through the right to healthy environment chapter of the handbook that we just released yesterday. And again, you can download the handbook from our website. You may have also seen emails from with them to download the handbook. But so you can look through it as we go through it. But I'm going to go through the handbook and then show you how, talk to you about some cases about the U.S. and the right to healthy environment, and then show you how to build an argument. So let's go ahead and get started. So this handbook is developed a couple of years ago. It aims to get practical and usable information into the hands of legal aid attorneys. When we're drafting the handbook, we look to use simple language. We look for it to be used every day, so make it very simple, easy to use, and then repetition. There's a lot of repetition, so that each chapter is really standalone. You don't need to read the entire thing to understand the chapter on right to healthy environment, for example. That's what we're aiming for. And here it's available for download on my website at this link. The other thing with the handbook is it's plagiarizable. We really encourage you to cut and paste any of it, all of it, into briefs, into community presentations. We have, this is not like your throw out everything you learned in law school about having to cite. We want you to just use this handbook, and so use it. So there's 5 major parts to the handbook. Part 1 is an introduction to the subject of human rights in our partner organizations, and it also goes through the principles I just went through about drafting the handbook. Parts 2 and 3 of the handbook are designed to give you an introduction to the human rights framework and provide the background necessary to start thinking about integrating human rights into your work. It's like a basic human rights 101. Part 4 of the handbook is designed to give you specific information to make persuasive human rights arguments. It's more like advanced human rights 1 or 2. Section 405 also, oh no, okay, sorry everybody, I was muted. Here we go. So I'm going to go through a little bit of the background of the handbook. Didn't realize that it had been muted for that whole time. Got it. So the background of the handbook. Sorry, I didn't realize that I had been muted for that whole time. But I'm just going to, what I said is thanks to Erica for giving us an introduction to the right to a healthy environment. Now I'm going to go through a little bit about the handbook and the right to a healthy environment chapter of the handbook that we just released yesterday. And then we are going to, I just need to mute a couple of people. Hopefully that helped with the echo. I heard it was echoing. Okay, maybe hopefully that helped. So go ahead and download the handbook while I get going. And so I'm just going to go through a little bit about the handbook. Another major point I want to make that I just made, and sorry for the problems, but this is a plagiarizable handbook. Use it. Cut and paste directly from the handbook into your community presentations, into your briefs, into your pleadings. into your PowerPoint presentations for your own staff. We want you to use it. We want you to cut and paste from it. No need to cite to the handbook. No need, just please use it, and use the statistics, use the introductory language. Obviously, you need to do your own legal research, always, for your own case. But, feel free to use this however it is useful for you. Okay. So in terms of the handbook, we have an introduction, which is just about the Center for Human Rights, our project partners, and our local human rights lawyering project. Part 2 is a Human Rights 101. It provides you with basic introductory information about the human rights framework, and starts you getting to think about how you might integrate human rights into your litigation and advocacy work. Parts 3 of the handbook is also basic Human Rights 101. It goes into international mechanisms, special rapporteurs and special procedures, and then our American Commission on Human Rights. Part 4 of the handbook is like an advanced human rights, maybe Human Rights 102, and it also contains sample opposition arguments that you may face in litigation. Then we get to Section 5, and this is the specific legal issue areas chapters. We have 12 so far. We're going to be adding another one next month on the right to counsel. The one that we just added, we just released a new version of the handbook yesterday, is on the right to a healthy environment, which this webinar is on. So I'm going to focus on that. And it actually starts on page 234, not 239, as it says on this page. So all of these legal issue sections of the handbook are formatted the same. They all start with an introductory language to introduce you to that specific issue. Defines the rights at issue, provides an explanation of what it means to frame a case in terms of the rights at issue. Again, feel free to cut and paste this if this helps you in your own trainings, in your own materials. We hope that this is a concise and hopefully some pretty simple language that you can use. And Erica went through this, so I'm not going to go through the details. The next section is the statistics section, and Erica also went through some of these with you. We hope that this provides you with some data, or at least resources where you can find data that you can add to briefs, memos, community presentations. Again, these are both domestic sources and international data sources. Then we get into the relevant human rights law, and this section of the chapter is divided into ratified treaties and then human rights instruments not ratified by the U.S. And the ratified treaties are always designated with the little American flag. Hopefully that makes it easy for you to identify them. It provides relevant articles from the conventions and the treaties and the different instruments that would be relevant to the right to a healthy environment. This is not all of the articles that might be relevant to your particular case. It's just a sampling. So again, you need to do your own legal research, and you may find something in that particular convention that is more on point than what we have here. You can find the hyperlinks, the blue hyperlinks will bring you to the full text of the convention. So easy to do your homework. Once you start from the handbook, you can use the links to take you to the full convention. This is another reason why we really suggest that this handbook is meant to be used online, electronically. We really suggest that you don't print it out unless you absolutely need to. Number one, we're talking about a healthy environment today, but number two, you can't access the links, which make this a much bigger, much more full document than it is if you printed it out and weren't able to view all of the links. Next we have so I'm going to go through just a little bit of what the different conventions say, what the different convention articles are relevant to the right to a healthy environment. The first is the International Covenant on Civil and Political Rights. Article 6 has every human being has the inherent right to life. So this is where the right to life comes from, that Erica mentioned, would be the ICCPR, the International Covenant on Civil and Political Rights, Article 6. The right to privacy comes from ICCPR Article 17. You'll see in some of the cases I'm going to go through a little bit later on, the right to privacy has been really central to some of the international cases on the right to a healthy environment. Right to an adequate standard of living, including food, water, clothing, housing. That comes from the International Covenant on Economic, Social, Cultural Rights. This is not a convention that the U.S. has ratified, but you can, doesn't mean you can't use the language. And if you're curious about more, if this is the first time you've been on one of our webinars, or you're curious about how to apply human rights law in a U.S. court, please, read through the handbook, but also we have additional webinars on, the basics. How do you, what do you do about ratified treaties? What do you do about treaties that the U.S. has not ratified? How do you use these in court? The basics, we've had several webinars going through introductory human rights law, so please check those out on our website. I'm not going to go through all of that today. Another, good source is the Protocol of San Salvador, Article 11. Everyone shall have the right to live in a healthy environment and have access to basic public services, and state parties shall promote the protection, preservation, and improvement of the environment. And this comes from the additional protocol to the American Convention on Human Rights in the area of economic, social, and cultural rights, and was called the Protocol of San Salvador. It's a nickname, but that's one of the only human rights conventions that mentions specifically the right to a healthy environment, and not one that the U.S. has ratified, but at least we're talking about a convention in the Americas. Okay, so then the next section of the handbook goes through relevant law in U.S. courts. So this would be state and federal court cases citing human rights law that has to do with the right to a relevant environment. This is just a sampling. We've only have actually 4 different cases in this section on the right to a healthy environment. You again should do your own legal research. There are other relevant, cases that could be relevant to your fact pattern. Also want to point out, let's not argue that the U.S. Constitution guarantees a right to a healthy environment. I think that if you look at these cases, especially this Dole case out of Hawaii, you can see that there have been others who have tried that and who have failed. So maybe we need to wait a little bit on that one. But I think you definitely could consider making that argument under state constitutions. Erica went through all the different states that have right to a healthy environment articles in the Constitution, and that's also in the handbook. I'm going to go through that in a few minutes. This 1999 Montana case Montana is one state that does have the right to a healthy environment in its Constitution, and the Supreme Court in Montana in 1999 decided to apply strict scrutiny when a right to a healthy environment was implicated. I also included a couple of Alien Torts Claim Act cases. These are not, Erica mentioned, these are cases where non-U.S. citizens are suing about violations, possibly about right to a healthy environment, violations in their home country. So violations of international law that occurred in other countries. These are important because the U.S. courts are looking at the right to a healthy environment in an international context. And this Binal case is very important because the Fifth Circuit held that there was no universal acceptance of the right to a healthy environment, or basically no customary international law on a right to a healthy environment. This was back in 1999. A lot of things have changed in the last 15 years. We have a international expert on the right to a healthy environment. We've had a lot of developments in courts and in international courts and also state courts. So would this, be the same today? Probably for the Fifth Circuit it would still be the same today, but maybe, what about other courts, especially state courts, where the state constitution has a right to a healthy environment included in it. So we have the citation to the executive order that Erica mentioned. We also have the citations to the various states that include the right to a healthy environment in their state constitutions in the handbook. Also have international statutes, cases before international bodies, and cases before regional bodies or national courts. Again, these cases are just a sampling. There's many more cases that deal with environmental issues, environment and human rights issues. As we stated at the beginning of this section on cases before regional or national courts, there's a few other sources, including the UN and Independent Expert on Human Rights and Environment website and this compendium, United Nations Environmental Program Compendium on Human Rights and the Environment materials and cases. Those are great sources for additional cases and materials. So I am going to skip ahead and talk to you a little bit about one particular case, just for the sake of time, and that is the Mossville case, which is listed in this section. This is a case, I have the citation here on the slide, but this is a case that was brought before the Inter-American Commission on Human Rights. It was first brought back in 2006. We had an inadmissibility decision in 2010. We're still waiting for the merits to be heard, but this case is important in that it's comes out of the U.S. and the petitioners are arguing for the right to a healthy environment on behalf of a community in Mossville, Louisiana. It's a historic community founded in the 1790s by African Americans. Traditionally, it was a fishing, farming, hunting community. They developed, many kinds of traditions based on preserving environmental conditions. Since the 1930s, the state of Louisiana has authorized a total of 14 industrial facilities to manufacture, process, store, and discharge toxic and hazardous substances in close proximity to Mossville. This is facilitated by industrial tax incentives, zoning, and also environmental and public health laws that have failed to provide protection and require safe distances from these facilities. So the petitioners, are basically alleging a public health crisis caused by toxic pollution from these facilities in their community. And they point to scientific evidence supporting the serious and disproportionate levels of chemicals in the blood of Mossville residents, as well as high levels of respiratory and other illnesses connected with the chemicals. And they're also, alleging environmental racism, discrimination in this context because this is a majority and historically black community. For example, just to give you some of the statistics that they cited in their petition to the Inter-American Commission, 91% of the persons surveyed reported at least one health problem known to be related to the exposure of chemicals. 84% of the residents had nervous system problems, 71% cardiovascular problems, 57% skin problems, and then there's a lot of mental health problems associated with the exposure to chemicals as well. So again, brought this case before the Inter-American Commission on Human Rights. there's a very good, in their petition, there's a very good explanation of the difference between racial discrimination analysis under U.S. law and under human rights law. So I'm going to just point that out to you. This is an important part of the environmental justice conversation, but if you want to sort of see the difference, see them very clearly and simply explain the different analyses, I think they do a great job. So take a look at their petition, which is linked to in our handbook. So these were their arguments. The petitioner's arguments. First, the U.S. failed to protect the rights to life and health of the Mossville residents, and they cited to the American Declaration of Human Rights, Article 1, the right to life, Article 11, the right to health. They also mentioned that the ICCPR, the International Covenant on Civil and Political Rights, Article 6, provides the right to life when the U.S. has ratified that convention, and the Convention on the Elimination of Racial Discrimination, Article 5. The U.S. has also ratified that convention, and that includes a right to health. They also noted that the Commission, Inter-American Commission on Human Rights, has recognized the interrelationship between the rights to life and health in the context of environmental degradation, and they cited to a 1997 case that came before the Commission, a good decision, which I suggest that you also take a look at. And then what did the U.S. government say in response? And this is, sort of telling in terms of arguments that you might come up against. First, that there's no such thing as a right to a healthy environment. They said there's no such thing under the American Declaration, under other human rights treaties, nor as a matter of customary international law, pointing out that there's no particular reference in any of the main conventions that never states that there's a right to a healthy environment except that additional protocol, which again the U.S. has not ratified. And they're also arguing that there's no right to a healthy environment as a matter of customary international law. They said even if one were to assert that customary international law somehow existed on the topic, no such rule would bind the U.S. as it has never accepted such a rule and in fact objects to the creation of such a norm, making it what is known as a persistent objector so that any such norm would not apply to it. If you want its full arguments, the full arguments of the U.S., there's see page 56 of the handbook for a link to the U.S. petition in reply to the Mossville petitioners. So this is a great case. Again, we've only had the admissibility decision come through, so the commission has said yes, this petition is admissible. There's been a exhaustion of remedies in the U.S. And that they agree that the claim, that there's a potential claim for a violation of the right to life and the right to privacy. So we don't have the merits, but I still think this is a great case to take a look at in terms of the arguments that the Mossville petitioners made and in terms of the arguments that the U.S. made in response. And if you're curious about bringing a case before the Inter-American Commission of Human Rights, I want to point out again that on page 28 of the handbook we have a whole section on how to bring a case before the Inter-American Commission on Human Rights, which is written by Carrie Bettinger Lopez at the University of Miami, who's one of our project advisory board members. And we did ratify the OAS Charter, the Organization of American States Charter, in 1951. So the U.S. does come to the table in these Inter-American Commission cases. We talk about enforcement and implementation. That's another story, but it is a way to get them to the table and force them to make replies to petitions like this one. We're running short on time, so I'm going to go quickly through the rest of the handbook section. But we have relevant law continued. We have some treaty body and special procedures commentary and recommendations. Again, a lot of links to reports by John Knox, the UN independent expert on human rights and the environment. We have sample arguments, which is what we're going to do next is build one of these sample arguments. We have a sample argument from the Mossville case and then an additional argument which would be sort of a policy argument about some type of regulation or policy, local policy that would need to be stepped up, that you would argue would need to be struck down because it violated the right to a healthy environment. And again, these are two sample arguments. We encourage you to cut and paste. This may not be relevant to your exact case, but you can see how we might, what an argument might look like that we would plop down into a brief. And again, I'm going to go through how to build this argument, so I'm going to sort of skip through this right now. We then have talking points, so these correspond to those sample arguments. It would be talking points which you could use in motions, arguments, or during a trial. If you just wanted to print these out and take them with you in case you wanted to make these arguments orally in court, go ahead and do that. Again, they correspond to the sample arguments. So sample argument number 1 corresponds to talking points number 1. And lastly, section 5.12.8 is other resources, and this is a catch-all section. Provides you links to other international law guides, reports, articles, laws, other sort of resources. And this is a great group of resources, so take a look at those as well. Okay, so building a human rights argument. So first thing to think about when we talk about making these human rights arguments in U.S. courts is knowing your forum. So are you talking to a court? Is it a state court? Is it a federal court? Who is the judge? Who are the law clerks? Who appointed the judge? Is this judge friendly to your cause? Is this judge friendly to international, transnational issues? Did this judge attend a training on international human rights law at the Aspen Institute, for example, that used to give trainings to judges on international human rights law? Does he have a copy of the American Society of International Law bench book, which has a section on human rights law? Are the law clerks human rights buffs? These might be judges who you consider making human rights arguments to. It could also be that judge who really is, you know them to be very, very friendly to your cause, to your organization, and they just need something to hang their hat on. The next thing you need to think about, why are you going to use a human rights argument? Is it going to help your case? Why this particular case, and why at this point in the case? It's going to be very far and few between cases that you decide to use the human rights argument at this point. We're obviously trying to work towards normalizing human rights and getting to a point where we make these arguments all the time. But at this point, it's going to be a lot trickier than that, and it's going to be far and few between. So again, think through at what point in the case are you going to use argument? Are you going to, is it going to be during motions practice? Is it just going to be in a letter to your adversary, whether it's a policymaker, whether it's opposing counsel, whether it's you're going to do it as an organization to the judiciary as a whole, something like that. Or is it going to be in a brief or a memo, a legal memo? So once you think through all of that, then you want to, this is sort of the ideal for how we think you should add a human rights argument in your court case. This would sort of be either in motions practice orally, or if you're putting it into a brief. So you first start by making your arguments based in local, state, and federal law. Then after that, this is the icing on the cake. These human rights arguments are never made alone. Then you make the human rights argument. So ideally this is a case where you have strong local law, strong state law, strong federal law, and this is just one more good argument as to why the judge or the jury should decide for you. So you start by explaining why the human rights law is relevant to this court in this case. Why should they pay attention to the human rights law? Why are you explain why you're putting human rights law into this particular brief, and I'm going to give you an example of that in a second. Then you want to introduce your hook to the human rights law, and this is sort of the same thing, but why should this court pay attention to your human rights law? Then you introduce the human rights law itself, and then you do your analysis. So, looking at what this looks like. This is an example of an explanation of why human rights law is relevant to this court and this case. The opinion of the world community, while not controlling our outcome, does provide respected and significant confirmation for our own conclusions. And this comes from Roper v. Simmons, which is the case which struck down juvenile death penalty in 2005. We also have Lawrence v. Texas, which is the anti-sodomy law case from 2003, both cases where the court looked to international custom, international law in the Roper v. Simmons case in striking down those two laws. You can also look at our handbook section 4.2. We have a bunch of different sample arguments that you could use as to why human rights might be relevant to this court or to this policymaker. This particular argument is just that it's sort of a sister jurisdiction argument, right? Like you can look to the state next to you to see what they did. You can look to the jurisdiction next to you to see what they did. That is also the case in terms of international law. You can look to human rights law. You can look to what other nations have done if you're trying to make your decision court. And you have to think through which of these, relevancy arguments as to why human rights is relevant, which of those is going to work for your particular judge or your particular policymaker. Then you want to introduce your hook. It could be that your state constitution has the right to a healthy environment. It could be the fact that the right to a healthy environment is becoming widely recognized. There could be lots of other ideas for what exactly your hook would be. Maybe there was some news recently about the right to a healthy environment, or maybe there was some movement in your town. You live in Santa Monica and you just passed the right to a healthy environment ordinance, something like that. But something that would direct this court and be like, oh yeah, okay, I see that this is relevant. Then you want to introduce your human rights law itself. And you really don't have to stick to the ratified conventions. You can go to the cases. There's all sorts of cases in the handbook that we just went through. You can go through the treaty body commentary and recommendations. Often the language that the human rights law provides, and it could be from the treaty bodies, is much more relevant and much more on point than anything you're going to find in U.S. law. So I really suggest use language that's on point more than what's ratified or what's in the conventions. And again, these are more policy arguments. You're not saying that this court has to follow this law or what this treaty body did. You're saying this is something you could do, court. This is what this other jurisdiction did, court. So why not just consider it? You're not saying that this is enforceable and that they have to do this. So then you want to add the facts of your case and analyze. And this is just an example, very general example, since we don't have a specific facts and specific case to go through. So I'm going to end there so that we have some time for questions. I just want to note that we're having another webinar on the right to counsel on June 16th, and you can register on our website. And again, the handbook, and I just went through the handbook chapter, is available for download at that link below. So I am going to go ahead. If you have a question, if you can let me know, send me a chat or a message, and I will unmute you and allow you to ask your question. If I can just, so I'm going to just give you a couple of minutes to let me know that you have a question. There's a question. You can also raise your hand if you see the little hand raising. Okay. And feel free, Erica is here with me, so if you have any questions for Erica, she's also happy to answer questions. Any questions from folks? I'm not seeing questions yet. I'm going to try this too. I'm going to actually go ahead and I'm not seeing questions from folks. If you do have a question, let me know. Just either chat with me or send me a question in the question box. I'm attempting to. No questions. Do you have anything else to add, Erica?
I don't think so.
Okay, well, I guess there are no questions unless I'm missing it. Feel free to email us with additional questions. You can also feel free to give me a call. Many of you will have my contact information from emails I sent out earlier this week, or you can find it on our website. But if you think of questions or if you want to discuss a particular case, we're really happy to do that with you at any time. So thank you so much for joining us on the webinar. And note that we have another webinar coming up June 16th on the right to counsel, and it'll be specifically in the civil context for legal aid attorneys. So hope you'll join us then. Thanks, everyone.